Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam. Pam, at one time we all got our news from sources we at least thought could be trusted. It might be the New Yorker, which was famous for fact-checking, or Walter Cronkite or Time Magazine. Today, when you're in a debate with someone, they can come up with information you've never heard of from a site you've never seen.
Well, and sometimes also you don't even know where the news or the facts you've gotten have come from. They come from the internet, and who knows who put something up on Wikipedia. I will say, for anybody who is listed on Wikipedia, it's often quite educational to go in and view your own listing and find out things about yourself you didn't know before.
I'm afraid to do that.
I advise you to stay afraid, be very afraid. But one of the places that's probably the last institution in all of America to have gone to the digital age in a lot of ways is the Supreme Court of the United States. They famously do not televise their oral arguments. One of the justices was quoted testifying in front of Congress saying they'd have to roll the cameras into the courtroom over his dead body. There was a set of famous episodes a couple of years back where it turned out that the majority of links in Supreme Court opinions were to dead websites and the like. And so the question of how the Supreme Court gets the facts it uses to decide about cases, how it thinks about arguments and everything, is something that I think probably our listeners don't know a lot about, but it's really interesting, and it's changing in important and really unregulated ways. And we have with us today really somebody who is the right guest, not just because he's argued dozens of cases at the Supreme Court, but also because he's thought really hard and long about these issues of how the Supreme Court gets its information.
That's right. Our guest today is Jeff Fisher, a frequent guest of our show. He's co-director of the Stanford Supreme Court Litigation Clinic, along with you, Pam. And he wrote a terrific, interesting article entitled Virtual Briefing before the Supreme Court. Welcome, Jeff.
Thanks for having me.
Yeah, thanks for coming on the show again, Jeff. And I wonder if you could say a little bit about how normally people present their cases to the Supreme Court, and then what you discovered in the research for your article.
Well, I think what you mean by normally is, setting aside the internet and this new thing we're talking about. So the traditional method of submitting a case to the court has two stages, and the most important is the briefing stage, where the lawyers research and write written documents that they submit in little booklets that are put together for the justices, just in hard copy that gets sent around. And so it's a highly formalized process where the parties submit a written document according to specific rules under a specific timetable in advance of the second stage of this case, which is the oral argument, where the justices, after they've read those booklets from the parties and from other interested groups that might want to weigh in themselves, then has an opportunity to ask questions to the lawyers in about an hour-long session. And then they take the case under submission with, almost without exception, traditionally no other opportunity for information to be given to the court after that.
But you know the information that's in the other side's booklets, right?
For sure.
Both sides share their booklets with each other, so you know what the arguments are that the party on the other side is making. You know what the arguments of the amici are, and you have an opportunity always to respond to them.
Right, and I think that last part is the critical part, is you have an opportunity in your own written briefing back and forth to respond to anything the other side says, and then certainly at oral argument, because all the written submissions are due well in advance, you have an opportunity to address anything you want at oral argument.
And I know, after the oral argument, this is always true for me, and I imagine it's even true for you, as you're walking down the steps of the court, you always have this moment where you think, I should have said X, or now that I think about it, here's another thing I wish I could do. And there was really nothing you could do about that except tell all your friends afterwards,
right.
I had this thought.
Well, you may remember Justice Jackson, when he was a lawyer, argued a couple cases at the court, and he was famous for saying every Supreme Court argument he gave, he had three arguments: the one he planned, the one he actually gave, and the one he wished he gave afterwards. And so that third argument we all have in our own minds starting moments later.
Yeah, there's this wonderful Yiddish word, Steppenwit, which is the things you think of as you're going down the stairs afterwards. Joe?
Yeah. That was going to be my comment, Pam. So great minds think alike. So that's how it used to be. And tell us what you found in your article. How's it changed?
Well, so the jumping off point for this particular piece that we're talking about is in one sense maybe surprising in the sense that the Supreme Court is this institution that doesn't have cameras and seems kind of like a laden institution in tradition and certainly has not entered the internet age in some ways. But on the other hand, if you consider the Supreme Court as just one of our three branches of government and look at what the other two branches of government are doing, they're dramatically changing the way they get facts and the way they speak to the way they speak to the public through Twitter, social media, and all the rest. And so why shouldn't the Supreme Court be doing the same thing? And so what my article is about it is actually true, in fact, that the Supreme Court itself is now starting to procure information from online websites in various ways, and not just what Pam was referring to as the court started to kind of dip its toes into some basic fact gathering, but maybe even more interestingly, legal argumentation being submitted to the justices in online form that completely outside the Supreme Court's rules that we just described earlier.
And give us an example of this. What would a justice or one of their clerks, meaning a top former law student, law school grad that's spending a year working with them, what would these websites look like? Who writes them?
Well, there's any number of legal blogs to start with. SCOTUS blog is certainly the one that many of us in the practice start with. That is a blog devoted to Supreme Court cases and Supreme Court practice that gathers stories every day and posts a lot of information. And there are many, many other academic blogs and legal blogs out there. So that's the primary area. There are also many legal academics and other interest groups who are on Twitter, on other forms of social media like Facebook. And so all the things that we're using in all the other aspects of our lives are also true in the legal realm.
So there were two things that I wanted to kind of focus on with you. The first is it seems like there might be two different sets of legal information out there. That is just information that's out there floating around that existed prior to the case and isn't really case directed. And then there's this stuff in the legal blogs which is really directed at particular cases once the court has taken those cases. Is there a difference between those two kinds of information from your point of view?
Yeah, and I appreciate the general way of putting better the point that I should have just made a moment ago. But yeah, I think there are a couple big differences in that respect. One is that material that is posted in the midst of a case, as opposed to pre-existing material, can speak to the justices in a more pointed way than other things that were prepared outside of litigation. And the rules of evidence, just in ordinary cases, have always distinguished between documents prepared for litigation and those not. And so there's a version of that going on here. And that leads to the second thing, which is those kinds of postings in the midst of cases can take place in two particular high-sensitive time zones. One is the time zone after the parties have presented all of their written briefs and before oral argument, in a place where the parties don't have a chance to offer any written response. And the second sensitive time zone is right after oral argument, when the justices themselves for the first time have expressed their concerns, their questions, their ideas, and can be directly responded to in blogs in a way that, as we were just describing about the front steps, the lawyers themselves don't even have the right to do so under the rules.
This is Stanford Legal, and today we're talking with Jeff Fisher about his article, Virtual Briefing. Joe?
So what you're saying is you and Pam might be arguing on one side and someone's arguing on the other side. The argument's over, you think. You've all had your opportunity to say something. And now a third party who knows what the justices are interested in kind of finds out where they're hanging out, except these days we hang out online, or we're someone that works for them, one of their clerks that helps write the opinion. They're going to be hanging out here, and I'm going to make that argument that now, in retrospect, I think might be a winning argument for whatever I think the right answer is.
No, I think that's right. And just to, I've had cases where I have argued and then that afternoon there are people online saying, Mr. Fisher said X. Now let me tell you what I think why I think he's wrong. Or Justice Kennedy asked Mr. Fisher X, and here's the answer I would give to that question. And just to give, whenever we deal with new phenomena online, we often try to resort to old analogies. Imagine 15, 20 years ago, if the afternoon after oral argument, somebody had just called a justice on the phone and said, we understand Justice Kennedy was asking an oral argument today about X. Can you please put me through to him so I can give him my answer? Well, no way that person would have been put through to Justice Kennedy. But now through virtual briefing, those people are in fact getting through by posting these things online. The law clerks read them, and to the extent they're interesting and useful, we think they're getting passed on to the justices.
So one of the most fascinating pieces of the article is how you figured out that they're actually getting through to the justices. Do you want to tell our listeners a little bit about the detective work piece of the article?
Well, I have to say something I should have said far earlier in this conversation, which is I co-authored this piece with Allison Larson, who's a professor at William and Mary. And actually, Allie gets the credit for this piece of the paper, where she and a research assistant were able to go on Twitter accounts and public information on Twitter accounts and find out which accounts various law clerks were following. So we were able not to find every last law clerk information, but a substantial group of law clerks, and then find just through public computer information which Twitter accounts they were following. And so we found a couple of interesting things in that respect. We found that as you would expect, but also as you might worry, different clerks in different chambers are following different blogs and different professors based on things like ideology. Secondly, we found that some law clerks were signing up for Twitter accounts and following interest group blogs, websites, or fact-type information that had to do with pending cases. And so both of those things, just for Twitter alone, is concerning. And remember, Twitter is a place where people actually often have links to much more detailed analyses, or we could reasonably assume if they're on Twitter, they're probably on other places too.
So you can imagine, say, a law clerk thinking to herself or himself, okay, I've heard these two people litigate, but the person I'm really interested in is this person I'm following online, and this person's going to give me the truth. And it is a person that's going to respond actually to the case. It's not like some general person I get inspiration from apart from the case.
That's right. That's right. And I think many people are pretty upfront about this in terms of what they're doing. They and I don't mean to cast necessarily aspersions on it. I mean, I think we should have a part of this conversation that says, in some ways, opening up the Supreme Court to more voices, and one set of things can be a good thing. But just to stick with the way we're talking right now, and there are some academics, lawyers, and others who quite purposefully are saying, I'm putting these ideas out there because I think I want to put what I think the right answers are, and especially where they think for some reason the parties are either withholding information or not making the right arguments. And I think that, that starts to lead back to some of the problems we've talked about.
This is Stanford Legal, and today we're talking with our colleague Jeff Fisher about his article, Virtual Briefing. Joe?
Well, let's go with the other side of the argument. Suppose I say, as you just did, the Supreme Court ought to be getting other sources of information. You left a great argument dangling. I don't think you ever did. But let's suppose you did. It was a crucial response. You didn't make it. Thank God 24 other academics follow it and says, Fisher forgot to give this response. Mm-hmm. Here's the right response to you. Yeah. So what's the downside?
Well, let me just say a couple things about that. I mean, I think one is that I can even add to your argument first, because remember, every Supreme Court case really operates on two levels. There are the parties in front of the court who want justice in that one particular case, but in many ways, more importantly, there's also the rule the Supreme Court is going to establish that governs all other cases like that and all other parties like that across the country going forward. And so you want the Supreme Court to get it right, not just for the parties. If the Supreme Court gets it wrong, it's not just the parties who are affected, it's all these other people. So that might be all the more reason why you would want other voices to step in. You asked me what the problem with that would be, though. The problem with that goes back to the reason why we have the adversarial process, which is that there may be good reasons why parties didn't make that argument, or a problem with that historical analysis or theoretical economic argument or whatever it might be, that a party, if asked, would be able to expose. But if they're never asked and never offered an opportunity to engage with that argument, the justices or the law clerks or whoever might accept it as being valid and true without having a chance to test it the way we would test any other proposition in a legal setting, in a trial court or anywhere else.
Yeah, I mean, I'll give you an example of this that came from the United States against Windsor case that our clinic litigated, which was a case about the Federal Defense of Marriage Act. In the trial courts, the other side quoted from an article, scholarly article written by a psychologist about family formation and the mental health of children raised in same-sex couple households. It turned out they had quoted the article inaccurately. They didn't understand the implication, and we actually got an affidavit from the scholar saying, you got my article wrong. But the only reason we knew to do that was because it was done in the district court where the other side had cited it. Imagine instead that a law clerk at the Supreme Court had gone out and read the article and then told his or her justice, I read an article and it says this is what happens to the children of couples raised in same-sex households, and we had never gotten a chance to respond to it, right? That's, I think, some of what the worry is.
So it's a little like, I mean, the whole concept of like ex parte communication,
right.
That is, you don't want the judge in your case to talk to one party out of the earshot of the other because there's no right of response.
Right. And, a related analogy is what we do with juries. We tell juries that you're to decide the case based on the evidence presented to you by the parties and the instructions of the judge, and you're not to do your own research or your own fact gathering. And so why shouldn't the same rule at least apply in general on appeal?
Yeah, I mean, it's a little hard for just the reasons, though, that you were pointing to earlier, which is it's not just about this case, whereas
right.
at a trial, it is just about that case. And so if somebody loses their employment discrimination trial because they didn't make the right argument,
right.
that's on them.
Right.
But if they get a bad decision out of the Supreme Court, it's on, in some sense, all of us.
Right. That's right. That's why and that's why it's a hard problem. And again, let me plug Allie's work a little bit, because Allie, my co-author, has done not just this paper, but she's written some other articles about Amicus brief practice, friend of the court practice in front of the Supreme Court, and the Supreme Court's penchant for looking beyond the facts developed in a particular record in the case to try to figure out the realities of the real world, something that goes all the way back to what we lawyers call Brandeis Briefs, which before he became a justice, Louis Brandeis was known to say, here's how this really works in the real world, just as a backdrop for you deciding this important case, and that's important information for the court to know. But it's just that we're just the reason I'm invested in this paper, in this idea, is just we want the court to get it right, and we want the process to be as fair as possible.
We'll be back with more from our guest, Jeff Fisher, talking about virtual briefing next on Stanford Legal on SiriusXM. Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Joe?
Hello, Pam, and welcome again, Jeff. Jeff, right before our break, we were talking about this form of ex parte communication where a law clerk for Supreme Court justice or Supreme Court justice might decide a case in part on something the litigants had no opportunity to respond to. And it could be a brief written by a great academic. It could be a paid-for brief with the payment not publicized in that source. What's the solution to all of this?
Well, I think that it's hard to find a really good solution, which I try to be forthright about in my paper. But I think you have three basic options in a situation like this. The strongest medicine would be the Supreme Court could have a rule prohibiting people from trying to influence cases outside of the regular briefing process. So you could imagine some rule from the Supreme Court or maybe even from Congress that said that people shouldn't post things online with the intent of influencing a Supreme Court case. I think that's
Don't
probably—
you think that would violate the First Amendment?
You took the words right out of my mouth. So the Supreme Court can regulate lawyers in front of it, but can they regulate people who aren't directly in front of them? Probably not, and there are very serious First Amendment problems with that.
But they could certainly regulate themselves.
So that's the next thing. So they could internally regulate themselves by prohibiting their law clerks or even themselves from from looking at online materials. Again, it's a little bit like the jury analogy we talked about earlier, from doing their own research, so to speak, while cases were pending. And then there's the third way, which isn't so much to block information, it's to ask for more information, which is often a way out of First Amendment problems, more speech. So one thing that we suggest in the paper is the Supreme Court could say, look, it could have an internal rule that if some chambers is interested with an argument or an assertion being made outside the briefing process online, they ask the parties to address that before they rely on it. The Supreme Court has long invited supplemental briefing in various situations. It's always done it rarely, but it's a piece of the rules where if something new arises, whether it's a legal argument internally or some new fact externally, the justices sometimes ask the parties to address that. And they could do the same thing with online materials.
Yeah, and I think both of us have had this happen in cases we've done. I did a case where I did the oral argument. Then a couple of weeks after oral argument, we got a letter from the Supreme Court that said, here's a case that we've found that none of the parties talked about. Tell us what the implications of this case were. And we got an opportunity to file a 5 or 6 page explanation. And you actually had a more dramatic example of it than that.
Right. Well, 2 examples come to mind. I mean, one less dramatic, which is I had a case one time where the court issued an order a few weeks before argument saying, isn't this case moot? Haven't the facts changed in a way that takes away the legal issue? And you could imagine some clerk who's preparing thought, oh, my gosh, there's a problem here. And actually both parties filed a brief saying, no. That actually doesn't make the legal issue go away, and the whole thing was taken care of in just sort of an orderly process. The other example is a little bit less orderly, where we had a case involving the constitutionality of a statute from Louisiana that made child rape a capital crime. And the Supreme Court ultimately wrote an opinion in our favor, 5-4, saying the law was unconstitutional, in part because only a few other states had laws like this. And then a few days later, somebody on a military law blog said, wait a minute, the Supreme Court missed the fact that the military allows the death penalty for this crime as well. Ultimately, the Supreme Court asked us for a further briefing on it and then denied rehearing in the case, but perhaps in part because we were able to show that actually military law didn't necessarily say what the blogger claimed, even though the state took the opposite position. So there we actually had opposite positions, but we were able to brief it in front of the justices, and they decided to let the issue go.
So this would be sometimes applicable. What would it be like? We were talking in the break that if you wanted to really encourage and soup up and hype up the amount of outside the court lobbying, this would be the way to do it, because as soon as someone's successful in getting the Supreme Court to say, hey, we just read Bankman's log, the one thing we know is everybody that writes a log like Bankman's going to be encouraged to double their efforts.
I think that's a very fair point, and perhaps one very good reason why the court has been hesitant to do this thus far. But like everything else, it's a balance, and so fairness to the parties and to the law, as against maybe encouraging some additional behavior like this. I think that's for the court to figure out.
This is Stanford Legal, and today we're talking with our colleague Jeff Fisher about virtual briefing and the Supreme Court essentially in the modern digital age. Joe?
I wonder, we were talking about how that would work, and I suppose that how that would work, meaning how it would work to have the Supreme Court ask for supplemental briefing. I suppose in a way, if someone, I'm going to take my own name out of this, if Smith kept writing things that stimulated additional briefing, maybe it wouldn't be so bad. That is, you're encouraging Smith and people like Smith and nobody else.
Perhaps. And, it could be also that people just I think one reason why people are doing this goes back to, there's an argument for this, is that there is a sort of traditional way even to do this in a sense, which is what's called the Amicus brief process. You don't get to wait and lie in the weeds until arguments are developed the way I described earlier, which is troubling. But at least people can get their arguments in front of the justices in the old-fashioned way, if they would like. But doing an Amicus brief is a not insignificant burden, especially for academics sometimes who are working at public universities under limited budgets and haven't actually ever filed a brief in the Supreme Court before. And I think one reason why people do this is because it's just easier to write a blog post than it is to file an amicus brief. So I think something else the Supreme Court could do would just be to figure out ways to make it easier to get briefs filed or your voices in front of the justice through the formal rules.
Yeah, because it does cost a couple of $1,000s in printing costs to file a brief at the Supreme Court. So even if you're the academic, so you'll do the work for free, it's still $2,000 out of pocket cost to file a brief at the Supreme Court. The other thing about the court is it's such a private institution in so many ways. We don't get to see the justices in conference deliberating. We don't know what they're reading other than the briefs that are submitted and the like. And although the oral arguments are public in the sense that they have the argument in public, they're not televised and they're not videotaped. Do you think that's going to change ever at the court?
Your guess is as good as mine. It's worth making sure everybody knows there's the in-between, which is the audio files of Supreme Court arguments are now released within a few days of every argument. So I think the justices So I think the question then becomes, why are the justices perfectly free, perfectly happy to let audio files come out within a few days and sometimes that afternoon? And why do they stop short of cameras in the courtroom? And I think that it might be just a personal thing from their perspective, is that they think they do their work better, and the people that present cases in front of them do their work better if there isn't the possibility for, in our modern culture, being on camera in a soundbite culture.
Yeah, and I've often wondered, this was certainly, my justice said this to me when I was clerking, one of the things they liked was they weren't generally all that visible to the public. So my justice used to go for a walk around the outside of the building every afternoon after lunch, and he'd regularly walk by people who were carrying signs protesting his decisions who didn't recognize him. Right. And if they were on camera all the time, they kind of would be recognized.
Yeah, there's a deeply personal aspect to any decision the court would make in that respect. It's kind of like the retirement conversations we have sometimes, and it's like, should somebody retire or not? And it's easy to have these conversations, but then if you really stop and think about it, they're really deeply personal decisions that affect their lives. Maybe retirement more so than this, but still this too.
Yeah.
We've been talking with Jeff Fisher here about virtual briefing before the Supreme Court. And really the big issue I think we've looked at is how the Supreme Court is kind of coming into the digital age. And the answer is, in some ways, it's held the line. We don't televise the proceedings. But in some ways, it's entered the digital age like maybe our kids do furtively, where it's looking after it should, in some sense, at some forbidden sources of information. And we're wondering, maybe like good parents, what should we do about it?
And so we really want to thank you, Jeff, for coming on the show. I think we're pretty sure we're not going to see any notorious RBG tweets anytime soon. But it'll be interesting to see how this develops. So thanks to Jeff, and thanks to our listeners for joining us on Stanford Legal here on SiriusXM Insight.